Hi, everybody. It's still 80 degrees outside?
86.
Awesome. That's our weather. It's hotter when it gets later in the year and cooler when you get in the middle of summer. Strange. So are we going to have an early fall, or are we going to have, what do you think? Kind of hard for me to get a sense, because in some ways it was a cool summer, but then we had these hot bands, and now we're moving on towards fall, and it's getting hotter. I don't know, strange. Nobody wants to guess?
Extended, possibly.
Maybe. Maybe we should have we should have a betting pool, right? Wouldn't that be awesome? I'll put up 50 cents. You all put up $50 each, and we'll see how we do.
First snow or first negative 30 degrees.
Yeah, right. There are gonna be a lot of things to take bets on, right, as to how it's actually gonna play out. Anybody have questions on anything before we get started?
There's a lot in this chapter.
There are. Actually, if I were smart, I would ban questions from chapter 4. It's just way too complicated. No, there is a lot. And that corresponds to your final exam, to what you'll see at the state exam, and to practice. Chapters 4 and 5 and 6 taken together is probably the single most important core 3 chapters that are in the text and that we'll talk about. And so this is a great place to ask questions as I'm getting, specifically if you have context-related questions that you've seen, or you think for those of you who bought and sold houses with agents, this is a good place also to say, my agent did this, is that okay? Was that right? Was that wrong? Because sometimes the answer is no, that probably wasn't, and other times there might be an answer or an excuse, or at least we can use it as an example to sort of talk about it in hypothetical sense of whether it was a good idea or not a good idea. It's not always easy. Yes?
I was confused a little bit on the different brokerage terms, like a sponsoring broker and
Okay, we'll talk about that both tonight a little bit, but we'll talk about that even more on Thursday. In fact, even one of the slides in the PowerPoint presentation that I put in towards the end of the chapter is really based on what we're going to talk about in chapter 5. So when you're talking about agency relationships, and then you're talking about the brokerage business, and you don't sort of meld it all together, you get a little bit sometimes of a term before it's been defined, and that'll happen a little bit tonight. So hopefully I'll define that, but if not, you have to hold me to this. This is part of your responsibility. If we get through a class and you still don't understand something, you need to put that back on me and make sure that I clarify that for you. I do not mind teaching something ahead of when we're going to get there, because again, there's times when you'll need me to do that. Anything else anybody wants to mention, just so that I'm aware of it, or specific questions? Yes?
I was confused on how an agent got paid.
Oh, we'll talk about that more in the next class also. Chapter 5 is really about sort of the brokerage business, the inner workings, the relationship between that sponsor you're going to have and you as the sponsored licensee. And in that context, we should also then talk the next night about also what's going to cost you to be in business and how the whole relationship will work. So that's really the best time to answer that. But getting paid is pretty fundamental, not just for your own self, but the state's going to want to make sure you understand that all of your money comes to you through your broker and only through your current sponsoring broker, with one possible exception. That kind of thing. So, and also we'll talk next time about fee structures and things a little bit at least. I should have said something really smart like paid. Paid.
You work for free.
Is exactly it. Any other questions or anything? I'm not answering a lot of these, but we will get to them. They're all good questions.
yeah, I just wanted to know if the sponsoring broker and managing broker, is that the same person?
Can be.
Can be.
So in a small office, the sponsoring broker and the managing broker are probably the same. Sometimes the term employing broker gets used. That would be referring to probably the sponsoring broker. Every license has to be sponsored. Again, I'll repeat this on Thursday night. And so the sponsor, whoever sponsors the firm or the brokerage entity, if they also happen to manage that office, then the managing broker and the sponsoring broker are the same. But if I have a brokerage firm and I happen to sponsor the brokerage, say it's a corporation, the corporation's licensed, I may not manage any of the offices. If we have offices spread all over the state of Illinois, I might have a different manager for every office. The state basically wants to know if who the sponsored licensee is, who sponsors their license, but who also manages that office. So on your real estate license, it will eventually have your information and the name of your managing broker. And they'll have in their records who actually sponsors the firm. they basically want to be able to talk to two different brokers. The one who caused the problem or who the complaint has been filed about, assuming that's what we're talking about, and who their manager is. Those are basically the two important things. Again, we'll look at this in greater detail on Thursday. Other questions? All right, so let's talk a little bit about agency law, how it works, the context within which we're functioning as real estate agents. I always like to sort of clarify the terminology a little bit. We'll use terms in this course like licensee or even licensed candidate, which is what all of you are currently. You're all, except for Braden, who's now, well, you haven't gotten sponsored yet, right? So you're technically still a licensed candidate.
Yeah, licensed candidate.
Okay.
With a sponsor card.
Yeah, so so as soon as he gets his sponsoring broker in place, then he's a licensee. Now, the idea of being an agent is he becomes an agent as soon as he's actually representing someone, right? So that's, when we talk about the term agency, we're talking about representation. And that's an important core part of what we're talking about. So when you're someone's agent, you are their representative. And one of the things we'll start talking about tonight is who exactly, as a sponsored licensee, will you represent? Once you're a real estate agent, once you're a real estate broker and you're functioning, who are you going to be representing? And that, if you've read and understood, you may have figured out already, isn't probably exactly what you expected when you first came into the class. But it's important to grasp that, because it's one of those nuanced things that's different on a test than it is in practical language when you talk about it. And we'll run through an example tonight, even though it partially is in here to lay groundwork for chapter 5. All right, agency comes, a lot of this has come from common law, just the way in which things were. Now a lot of this is statutory. So let me just give you an example of kind of, you know, sort of a change from common law to sort of statutory behavior. So you saw me shake Braden's hand and congratulated him for passing the state exam. What's the history of that handshake? Where does that come from? Anybody know the detail, the background of where that comes from?
Pilgrims and the Indians.
Oh, long before that even. It goes back to England. It was the way in which a man who was probably right-handed demonstrated what? He was unarmed. He had no weapon. He had no dagger up his sleeve. And it wasn't even just a handshake. It might have been more of a kind of forearm grasp like this. If you see the old, you know, movies that have any, you know, that are period from the 15th century or whatever, that's what they're showing. They're showing more of a forearm grasp. Again, that's why the right hand, and that's why it was typically done by men. Women weren't armed or weren't in battle, and most people weren't left-handed, so that's how it evolved. Now today, you think about the last time you shook somebody's hand, I'm pretty sure you weren't sort of, you know, looking for weapons at the moment when you did that, right? These things change over time. So we did things a certain way at one point in time just out of habit or practice, but as things evolve and change, maybe that's not the best way to do it anymore. And maybe there are other reasons why you wouldn't. Culturally, I'm sure there are those of you in this room who that wasn't the norm for you. You know, maybe there's a bow or a wave or some other signal or something else where you didn't shake hands. That's not what you're accustomed to. The world is fast coming to this handshake thing where it's the norm because it's the way that, you know, business is now conducted in the West or in Western societies. But let's say that you think that's a problem. It's people are passing diseases, or again, you just have a different cultural perspective and you don't think shaking hands is a good idea. How would you stop this, you know, evil movement of everybody shaking everybody's hands all the time every time they want to congratulate them? What would you have to do to stop that practice in a forcible sort of way?
Memo.
You'd pass a law. You'd make it statutory that handshaking was not acceptable, or that if you want to congratulate somebody, you'd make it statutory that you had to, you know, do a proper bow or a curtsy or a wave, you know, a nod, something like that. And this is what's happened. Agency worked fine the way it was for a long time until we woke up one day and said, oh, there are better ways to do some of these things. But it had been common practice, maybe for centuries, that things were done a certain way. And if you want to stop common law, you want to change that, how it's actually done, the only way to do it is through a court decision, and that's not going to happen. But so it's better you pass a statute. So what was common law, which is where agency comes from, is now all statutory for real estate agents. So if you were to take a legal environment of business or a business law class and study agency, you might find that it comes across much differently in that context because they're looking at agency very different. In fact, if you studied agency in the state of Ohio compared to the state of Illinois for real estate, you'll find that it's different. This is legislated at the state level. So what we find today is that everything we need to know or want to know or should know about agency is articulated in the Real Estate License Act of 2000. Yes, it was rewritten in 2010, but in Illinois we're not terribly clever apparently. And so it's still called the Real Estate License Act of 2000. Now here in this slide, for those of you who have seen this, I just want to share with everybody, this is my kind of basic way of thinking of how, this will work. No. Yeah, there it goes. Of how the basic residential real estate transaction works. So it starts off in my head, right or wrong, with a seller. And then if you're going to sell your house, whose services do you engage? A real estate broker, right? You go out and you hire a broker. And we're going to call this broker the listing agent. Putting a property on the market for sale, that's a listing. We're going to put it in our multiple listing service or whatever other tool we have. That's a listing. So the broker is hired by the seller, and now it's their job not to sell the property. This may seem a little strange to you. It is not the job of the listing agent to sell the property, but rather to market and promote and advertise the property for sale. So it's your job to get it sold, but not necessarily to sell it. In Chapter 5, the textbook addresses something called procuring cause. The procuring cause of the sale is generally done by a buyer's agent, and we differentiate this. The industry counts every transaction twice. There's the side where you list it, and there's the side where you sell it. Those are two different sides of the same transaction. So the broker who's responsible for representing the seller as their agent, we call the listing agent. Now the listing agent wants to make this property known to the greater world, so you then take this and you put this into the multiple listing service. Assuming we're talking about a residential transaction. There is no MLS per se for commercial, industrial. There are websites that might serve a similar purpose, but they do not work the same.
And just to clarify, when they mention the selling agent, that's actually the buyer's agent, correct?
Right,
So there's
exactly.
a lot of confusion when I was going through the chapters looking at that, because they refer to him a lot as the selling agent.
Right, and the industry does this as well. So I'll clarify this as we get to the bottom of this, but Braden makes a good point. This is a critical concept to get out of this little diagram, is that the party who sells, the broker who sells the transaction is the buyer's agent. So the selling agent is the buyer's agent, not the listing agent. Right? It may seem silly, but that's really the way the industry talks. So we have the listing side of the transaction up into where the listing agent is going to put this in the MLS. And of course the MLS is making this property available to whom else?
Public?
Well, pretty much all to the other agents, to all the other MLS members first. So you've got all these other brokers. This process of putting that into their hands is called cooperation. So this is the model that the National Association of Realtors promotes, and that has been tested in antitrust cases on a number of times throughout the years. Basically the idea now that the listing agent cooperates with all of the other potential brokers in the market, meaning all of those who are driving around with who in their cars? Buyers, right? I mean, so on this side of the transaction, the kind of the bottom half of this transaction, this is where Braden was bringing up this term and reinforcing, and I can't stress this enough, you need to think of the buyer's agent also as the selling agent, because they're the ones who we think actually sell the property. There's this myth, but it maybe in part represent how some brokers work. I come to your house, I list it with you, you sign up with a contract with me, which we'll talk about in Chapter 6. I go home, I stick this in the MLS, I put my pajamas on, and I never move again until the house sells and I have to show up and do something. If I list the house for sale, I don't really have to ever set foot in it again. Who are the people who are going to be coming through the house trying to sell it? All the buyer's agents who now we can see, oh yeah, they're the ones who actually sell the house. I stick it in the MLS, I pay for advertising, I help you with staging, I advise you as the seller what to do, but I don't necessarily actually sell the property. So later in this chapter, when we talk about dual agency, remember that first and foremost, we see this as two separate halves to the same transaction. The listing side, which is on the top, and the selling side, which is down here on the bottom. It's distinctly possible you get a question either from me or at the state exam that basically describes a situation you understand perfectly about maybe splitting a commission, but then asks, what does the selling agent get paid? And if you don't understand who the selling agent is, you could calculate the math right, but apply it to the wrong person.
What happens in a situation, for example, that you have an open house?
Yes.
And there's a rich couple that just so happen to be walking by, they don't have a real estate agent representing them. They go in there and they say, I want to make a cash offer on this house. The guy who's listing it, what does he do at that point? I mean, that person doesn't have a real estate agent, so
Right.
is that one of the dualities or anything?
Well, there are several options.
It
One,
doesn't make sense that somebody would have to get compensated on that side if nobody was.
well, but you do, since there are two sides, it is not at all uncommon that as a listing agent, you hope to capture the other side as well.
Okay.
So there are several things that can happen there. Dual agency is one, which we'll talk about in a little more detail. The other is no agency, which is unusual, but if that rich couple were to say, I don't really want you to represent us, we just want you to do the paperwork, then ministerial acts would say, okay, I need you to fill out this form that says, I'm not representing you, I represent the seller, but I'll help you fill in the blanks if you want to make an offer. Does that make some sense?
But at that point, that agent would collect both sides. So-
Either way, yeah. Whether you repped both sides, you would collect both sides, or whether you repped only the seller, but the buyers didn't have an agent, either way, you could collect the full fee. Which is, of course, what you would like to see happen if you were the agent on that side. All right, so this is the basic idea. So if you've got this diagram or you have this available to you, just refer back to it. If you're just thinking about kind of the flow, it'll come up again in these slides, and I think I have it come up again in chapter 5 slides, because, again, this is sort of how I see this in order to be able to remember a few things here and understand how this works. All right, so I mentioned agency. It's just, it's really the relationship between the parties. The broker representing the seller, the broker representing the buyer. Brokerage agreements we'll talk about in chapter 6 at length. Hopefully you will learn not to function under oral agreements. There's a lot to be said in contract law, and an agency agreement is a contract. It's a contract for representation services. You can function under an oral agreement under some circumstances, but you will, as a licensee, have a lot less protection, if any at all, and maybe not be able to sue or otherwise protect your entitlement to a commission or whatever. So keep that in mind, and again, we'll address that also, written versus oral, in greater detail in some areas when we talk about brokerage agreements in chapter 6. There's a little bit of that in the text, but I'll talk about that with you at length a week from tonight for those of you who are here for that lecture. Other statutory definitions that are really important. You should expect to see questions on client, consumer, and customer, particularly client versus customer. So we'll talk about this in a little bit of detail. These are, again, definitions in the law to try and define a human being in whatever the circumstances you may find yourself in as a licensee at that moment in time. So client is the principal or the party you're representing. Or if we're talking about some other agent, who they are representing. So as we look at the duties of an agent, not just of a licensee, but of an agent in this chapter, those run to a client. That's why you need to know when someone is your client as an agent, as a licensee, so that you know, oh, I owe them all of these duties. As opposed to if they're just your customer, and this is, again, a little bit of an odd bit of thinking, because a customer, you think of somebody who's coming into your shop and buying something and generating some profit for you. That's not exactly right here. The customer could actually be somebody else's client or nobody's client at all. So looking at client, consumer, and customer, and sort of skipping over compensation here at a moment, the client is the person that you as the agent are specifically representing, or whatever agent we're referring to. A consumer is just a word to use to define human being, right? There has to be sort of a generic person that when we say consumer, we're not intending to mean client, and we're not necessarily intending to mean customer. We're just using a generic term. So that's the definition of consumer. It's just kind of anybody seeking, or any entity seeking or receiving services, right? So we haven't defined them. So the real difference is between client and customer. Right, so a customer is somebody who you are not representing or is not being represented at all, but somehow is involved in the transaction and is entitled to some duties, perhaps ministerial acts. So let's just take an example of, oops, where do I have this here? Way down here. All right, so I'll back up in a minute. But here's an example within that transaction that I just talked about. Same diagram, but now I've added who's a customer and who's a client. Right? The listing broker is representing the seller, therefore the seller is the client of the listing agent. The buyer's agent or selling agent, that broker is representing the buyer, therefore that's a client relationship. But let's say that somewhere during the transaction, when you're representing the seller, you have to do something on behalf of the buyer, or are wondering if you have to do something on behalf of the buyer. I argue that the buyer is your customer, not your client. You owe them fair and honest dealing, you owe them straightforward, you can't lie to them, mislead them, misrepresent things to them, but you don't owe them the whole list of fiduciary duties that you owe to your client.
Yeah, I had a question like this exactly on the test today, and I think this is pretty much covers this. As a broker brings a buyer to a listing where the seller's agent was present, the buyer asks the seller's agent questions about the property, to which the agent answers. And there was a lot of answers that seemed to be right, but the one I picked was every broker has to treat, either the seller and the buyer like a customer, because it was saying, I guess through there's an implied contract between the broker and the buyer.
Yeah, in
the
terms
broker
of
that had
treating them honestly and treating them fairly, that would be accurate.
right, but they didn't enter into a contract, so
Right.
that client wouldn't be a client. The buyer wouldn't.
And unless you're, the way the law reads, and this is a question straight off of our final, if I remember right, there's this idea of, if you're considered to be working with somebody, so if the buyer is somebody that, like that agent has shown a lot of properties to, then they could be their client even though they don't have a written agreement because of the implied agency. But if it's a situation where you're really representing the seller and now the buyer just sort of needs some bit of information, then you would just supply that based on your relationship to the seller and not owe the buyer any more than that. Does that make sense?
Yeah, that makes sense.
It really comes down to the specific nuanced language.
Depending on how much you do for that customer.
Yeah, and how long you've been doing it. If it's just for that transaction, you probably don't rise to anything more than them being your customer.
And they're not very descriptive in the question either. They
Well,
leave
and
a
that's,
lot of
having
stuff
poured
out.
over a lot of those questions with other question tests, where we pick those things apart because one change in one word
Yeah.
order can change the question.
Exactly.
Directly. So,
Mhm.
but that's a good example of why this is important, because that's a pretty fundamental thing that they're looking for. It's also helpful to know that's why you don't have to worry about getting 9 out of 10, just 3 out of 4, because I wouldn't get 100% on the state exam. There's no way. It'd be stuff I would look at later and go, oh, that's what they were asking. You're just not going to get all of those. All right, so let me back up here a little bit to these duties. No, I'm going the wrong way. I'm used to going up. Okay. So, again, to know the difference between the client and the customer. All right, under ministerial acts, this is a statutory addition that didn't exist under common law that is helpful to know I can do these things for somebody and not automatically become their agent. And we haven't gotten to this conversation yet. If you've read the text, you might have inferred this from there. It's possible to be somebody's agent and owe them duties when you didn't intend for that to happen, or you don't understand yet that that's happening. So with ministerial acts, it's a way for the act to say, as long as you're doing these kinds of things, that hasn't happened yet. Again, a common area on which you're likely to get a question. If an agent's doing which of the following, which is ministerial acts or whatever, that's a common kind of thing. It's been a way for IDFPR or its predecessor agency to carve out some things that as a licensee you can do without worrying about getting into an agency relationship by accident. Confidentiality we'll talk about in more detail when we go through the details. So here's this client versus customer kind of thing. Again, you tend to be working, you know, when you're representing somebody, that's your bread and butter. That's what you're doing. You know you're representing them, hopefully. They'll give you information that you retain that's confidential. A customer is somebody you maybe have a casual relationship with, if they're just walking into your office and saying, can you help me find some information out on this one listing? They call on the phone to the office. Maybe again, the party on the other side of the transaction, but your office is holding their earnest money and they just want to know, did you get the check? Those kinds of things. You can have those conversations and have those interactions without worrying about, did I accidentally become somebody's agent? Can I do that or whatever? So again, client versus customer. Who do you advocate for? Who do you represent? That's your client. Who do you treat fairly, honestly, as long as it doesn't in some way violate the law or disadvantage your client? Yeah, that's a customer. I think I probably talked about this already. And there's that again, that's the diagram I was talking about. So again, it doesn't have to be inside of a transaction, but you know, that's a situation where within a transaction you can see the difference in the relationship. If it's dual agency, of course, then that's a slightly different scenario. This is the typical single agency transaction. Okay, any questions so far before we dig into the fiduciary duties? And there's a little bit of things out of order here, so hopefully things will get clearer as we go along. So to be a fiduciary is to be a person who's been placed in a special position of trust and confidence. A fiduciary gives you the sort of position you would expect from maybe your parents or grandparents, you know, to where you can trust everything they do for you. Maybe it's your minister or cleric or somebody like that. Same kind of thing, where you just complete trust. So kinds of people who tend to be fiduciaries are, you know, board directors of a company. You invest your money in somebody's business, the board of directors owe you fiduciary duties because you expect them to treat your money with a certain amount of care and professionalism, etc. That's what happens here for us as real estate agents. We owe this full range of duties to our clients, and not necessarily to customers. It's part of what you'll want to understand the difference, but to our clients. So let's look at these in a little bit of detail. For those of you who printed the slides earlier, I added this line to make sure I didn't forget that an agent is an expert. Let's talk about, you know, care, sometimes reasonable skill in care, sometimes diligence in care. So reasonable skill in care, this is where you are advocating on behalf of your client, where you're doing your best job, but also this level of expert. Care is where you can't let your client down. The standard of conduct expected for a professional, a reasonable standard of conduct, is that equal to what would be expected from the average proficient real estate agent in that area. So it's also helpful to know, for those of you who are trying to figure out, well, how am I going to make this leap from, you know, I'm a stay-at-home dad today and tomorrow I'm a real estate professional, how do I get there? There is no obligation, there is no requirement that you have any experience whatsoever to be a real estate agent to represent a client. None. The Act does not at all talk in any way, shape, or form about your need to have experience. What it talks about, and it defines it right here in care, is that you need to have expertise. How you get that expertise, the statute doesn't really care. You can get it from your managing or sponsoring broker, whoever might be training you. You might be able to get it from another agent you're going to team with. I've got a former student here at the college who's working his first commercial deal, and he came to me for help with his broker's permission, a woman that I know, where he's hanging his license, and we're working the deal together. I don't have a lot of time. He doesn't have much expertise. I provide the expertise. He provides the time. So there are lots of places you can go to get expertise. Let's talk about what can happen to you in the business where you've been an expert and then all of a sudden maybe you're not. You work a certain area, a certain geography, a certain property type, and then all of a sudden a friend, a former client, whatever, calls you up and asks you to look at something in a completely different county, a completely different property type than you've ever looked at, and all of a sudden you can go from being an expert to not really knowing where you're at and what you're doing. An example is, let's imagine that this room right here is going to be a sandwich shop that we're going to operate in. We talked about this maybe a little bit in the last class about this idea of a white envelope and trade fixtures and all of this thing. So let's say that instead of this space, actually, that, you know, your client doesn't want this. You know, somebody you've done business with before, you've been in the business for 5 years successfully, they call you up and say, hey, you did such a great job helping me find houses to flip or rehab or whatever. I'm thinking about opening a restaurant. In fact, we're going to open a restaurant, and I need you to find me a space. So you're willing, and you say, sure. Maybe on your master plan, you even say, I wanted to get into commercial real estate. This is the perfect opportunity because I know this person. They've been with me before. They trust me. So you go out and you show them a bunch of property, and one of the places you find there has been operating there for a number of years, but it's not operating now, a restaurant. It has everything your client needs. He looks around and even says so. Everything here, this would save me $100,000. If I don't have to buy all this equipment, furniture, fixtures, this is awesome. The rent rate is right, the location is right, the food type is right, everything. And so you inquire, about getting a lease sent over. They send a lease over, documents are signed. He shows up on the day to take occupancy, and what's not there? All of the stuff. Even the things that were bolted to the floor or hung from the ceiling. Why would they all of a sudden not be there? Well, maybe the space was dark, as we call it, but not vacated. Maybe the tenant had closed down, but they were still paying rent. That happens. Happens fairly frequently. Remember when Lowe's closed their Aurora and their Oswego locations? They let everybody go immediately. They owed them 60 days pay because of the Warren Act, something we're not covering in this class. But they let everybody go immediately because their cost, in part, was owning, operating, running those stores, utilities, etc. So they saved money by just shutting them immediately. And so, those places have now, in some cases, Oswego, I don't think so, but Aurora has been released. So that obligation has been mitigated somewhat. But in the meantime, in Oswego, what are they probably doing? They're continuing to pay the rent, but they don't have the operating expense. Because some place is closed, it doesn't mean the tenant is in default. So it's distinctly possible that just because you wouldn't have known, oh, I need to ask things like, does the equipment stay? Or even something as simple as, is the tenant currently in good lease? You're out of your element. And so even though you've been in the business for 5, 10 years and you've worked with this party before, doesn't mean that you're an expert. And again, that can happen in a lot of ways and a lot of reasons. Just all of a sudden, going up to Evanston to do a transaction, you can be out of your element. If you've never shown condos downtown Chicago, just setting up the showings and arranging them and how to get the keys is a completely different process than how it works in the suburbs. So again, remember that importance of expertise. It in some ways saves you because you don't have to be an expert yourself. You can get that help in your office when you start, but it can also be a double-edged sword because later you're doing something you haven't done before, but now you're more confident and you may forget, I need to get an expert. I need to pair with somebody, co-list with somebody, whatever. So expertise is extremely important.
Do you get paid for being the expert?
Yeah, you should. I mean, like the deal I have with a former student, I don't know if I'll get paid. We have to close a deal, but we have an agreement as to what's my share and what's his share. It's effectively a referral arrangement is what it really is, but where I agree to stay in and do it actively. I don't seek those, but I get them from time to time. So yeah, absolutely. So that's the deal. Why do it for nothing? Some offices have mentoring programs where, as an existing agent, you might make a little bit of money if you help a new agent through their first couple of transactions. It's the kind of thing you can ask about as a new agent when you're interviewing brokers is how, what kind of training you have, do you have any mentoring, and well, do I have to pay for that, are you paying for that, is anybody, people doing it out of the goodness of their heart? Because agents are much more willing to help new agents if they know they're going to earn a few $100s out of the transaction as opposed to just doing it because their broker asked them to. Every office will be different in that regard. Next duty, obedience. Obedience is pretty straightforward. The client says jump and you ask, how high? With what exception? Lawful or legal instructions. right? So if the instructions that your client gives you are legal, you follow them. It's that simple. Your client has the right to be stupid. Your client has the right to be completely short-sighted. So let me give you an example, if I may. We're coming out of this time in the market when there have been a lot of foreclosures and short sales. That market is getting a little bit thinner as time marches on. But if somebody got into the real estate investing business in 2007, for example, they would have noticed that house prices continued to march downward significantly for several years. So if you bought a place in 2008, you might have been kicking yourself by 2011 saying, man, I could have waited and got the same place for 10%, 20% less money. Well, if that's your mentality about real estate investing, if you see a place on the market that just came on the market today for 300, you might want to rush right in and make an offer of 210 or 220 or 240. And if you do that to some seller who believes that the market is vastly improving and they've got the best house in the subdivision, what's a really low offer going to possibly do to that seller?
They're not gonna wanna deal with you.
Yeah, they're going to now not going to want to talk to you at all. So as an agent representing that particular buyer, you might want to say to them, look, if you make this brand new listing, top of the line, you know, best staged house, perfect condition home in this subdivision, a really low ball offer, I think the odds are they're not going to want to negotiate with you at all. They're just going to tell you no. And if then you come back with something closer to their asking price, they're really not going to even want to be dealing with us. And if your client says, I don't really care, I want to offer them 200 grand for their $300,000 asking house, that's a legal instruction, right? So as a buyer's agent, you have a couple of choices. One would be to just say, no, man, I can't handle this assignment, I quit. You have the right to do that, subject to your broker. Your broker, you know, as we'll talk more, would have the right to take that over and assign it to somebody else. But you have the right to say, I can't do that with a straight face. But if you take it, your other course of action, and now you write up this offer for $200,000, you have to go and present this, either to the other broker or maybe even to the seller. I hear frequently agents say something like, I'm really sorry about this lowball offer. You can't do that. Because if you take that assignment to present that $200,000 offer on that $300,000 listing, what is it your job to do? To try and convince the seller they should sell that house to your buyer for 200 grand. That's your job. Take it or leave it. You're all in or you're out. There is no apologizing to save face to the other broker so they know you're not the idiot in the equation. Doesn't work like that, right? Because all of your duties run to your client. You're representing them and they want the house at 200 grand. So you gotta go and you gotta present it and you gotta do the best job you can. Doesn't happen a lot, but it does happen from time to time where you'll completely disagree with a tack your client is taking. If it's legal, you help them. You help them to do what they want. Again, you can tell them however tactfully, politely, firmly you want in your client relationship that you think they're being foolish. In fact, I would argue you owe them that opinion, but after that, you either do the deed or you walk. Okay? So that's an important thing to understand. It also happens if you take an overpriced listing, which we'll talk about a little bit as well. Loyalty. And you'll notice I'm assuming that they put this in a nice acronym of COLD AC so you can remember all of these fiduciary duties. I put them in that order even though I really prefer to teach this in a different order. So that's the only reason I'm going through them in that order is because it spells out the acronym they have in the book. So loyalty. Principle comes first. In general, you put your client's interests ahead of your own. That includes your own self-interest. Now, this can make it sound like, seriously, if my client calls me at 5 a.m., I gotta get up and get out of bed and go show him my vacant property? No, not like that, within reason. When we talk in the contracts chapter about how important it is to get a contract signed up, then there's a little bit of that that shows up. But in general, what we're talking about here is you are either an investor or you are a real estate broker on that deal. You're probably not both. So again, an example from experience, not likely that this ever would have been a problem, but just shows how it works. Many years ago, my wife and I were looking for a home that we had specific criteria on. Some of them were a little bit odd, but those were our criteria. At the same time, we took on a client who every once in a while, their criteria would overlap ours. So my wife and I were previewing a house, and it was perfect. It had everything we wanted. You know where Leonard's Circle is in Aurora? They do the cool Charlie Brown Christmas stuff. It's on Leonard's Circle. It met all of our criteria. One of my criteria, I have a ham radio license, and you can't erect, like ham radio operating towers in the middle of the city, or even particularly in subdivisions. Completely can't do that. Leonard Circle backs up to a piece of property that now may be owned, maybe retention pond, but at that point in time was completely undeveloped. And I thought, oh, you could even buy a little piece of property from this neighbor, and I could do that there, because that little square I would need of 20 feet square wouldn't be in the subdivision. Absolutely perfect. So of course I turned to my wife and said to her, now remember, before you and I go anywhere on this property, we have to show this to the so-and-sos. And she looked at me and she said, no. Yes, we do. She knew I was right. So we did. So we called these clients of ours because it met their criteria as well. While she was showing the couple the house, the woman turned to her and said, hey, this place would work for you guys. And my wife turned to her and rightly said, that doesn't matter. Yes, you're right, but that doesn't matter. You guys decide first. If you're not interested, then Cliff and I will decide what to do with it. Guess what happens in the long run? Those clients bought that house. Now, somebody always wants to ask the question, well, how would anybody have known? Nobody would have known. That's not the point. The issue is, it was very clear and simple to me that even though we were looking for ourselves, when I knew we had an active client who was looking for that kind of home, I owed them first shot at that. This also comes up in cases where you are meeting with somebody, interviewing them about what need they have, and you find out that what they're selling, buying, whatever, is super cool. You didn't know about it. And all of a sudden your investor juices kick in and you realize, ooh, if I could get in ahead of them on this, I could buy that property, I could make a bunch of money on it. If you walk into a deal or knowledge on a deal by virtue of being a real estate licensee in Illinois, be very careful. Do not scoop the person who brought you to the deal when they're not a licensee and you are. I've seen Illinois cases where the agent lost all of the profit they made and hundreds of thousands of dollars in fines, sanctions, and their license. So if you are an investor, learn to separate those two. I'm not telling you don't have a license if you're going to invest. I do that. I have a license and I comfortably own and manage property, and that's okay. Just understand that this duty of loyalty, if you've got an active client, you need to make sure they're aware of what you're doing, or that you say, oh, my client is doing this deal, not me. And if that deal dies, you might even want to get a signed waiver from them to say, hey, I'd like to go after the property. I did that recently. We didn't pursue it, but I at least traded emails with somebody to say, if you don't want this, do you mind if I pursue it to see if it's of interest to my partners or people? Once I had their note back that said, no, I don't mind at all, I'm definitely not interested, then I felt free to go ahead and pursue it. Disclosure. We're going to talk about this in two levels. First here, what it means for you as an agent, and then we're going to come back, and the textbook talks about duties of your seller, and I'm going to tell you that disclosure has two aspects. Your duty here to keep your client informed of everything that's relevant to the transaction or the property, what's going on. You have an out-of-town seller, for example. They've already relocated. The house is vacant. They're going to want to know, how many showings are we getting? Are the people serious? What do they think about the price? What kind of feedback are you getting? They have the right to make informed decisions. It's your obligation to keep them informed, hence disclosure. Did 3 more houses just come on the market in the subdivision? That kind of thing might have happened recently. Did the bank on a short sale just change their position and say, no, we're no longer going to take that price, now we want more money because the market's improving? You need to share that with these people. Whatever it might be that relates to them. The zoning might be about to change. This is a scenario thing you can see somewhere. You go to meet with a prospective client. They're just prospective clients at this point in time. and they say to you, we really want to get out of town, trying to retire, move to New Mexico, we've got another place there, and we really want to go. And you just read that day in the paper that the city may be planning to change the zoning on their property, and if that happens over the next year, the property could double in value. Do you remain silent and say, well, it's just in the newspaper, they could find this out, and they told me they really want to leave? Or do you tell them? Disclosure says you tell them at that listing appointment. By the way, I don't know if this is going to happen, but I just read this in the paper, you may want to check it out. I'm happy to list the property for you, but be aware that if this article is right, and if the zoning changes in a year or two, this property could be worth a lot more money. Then if they say, no, we've heard that rumor, we'd rather go, you're great. But if you never tell them, and then maybe you even do a dual agency deal with some investor you know who buys the property because they hope, they want to speculate on that kind of an increase, you've really disserved this first people by not telling them what the potential was. Right? So again, that's disclosure. Whatever is relevant to your client, you need to keep them advised of what the possibilities are. Those examples were with the seller, but it could be with the buyer. So,
I guess my question is more generalized question when it comes to the act itself.
yes.
I mean, the act seems like it sort of formalizes all these individual sort of items that are within sort of the real estate business, so to speak.
Sure.
So, why are they so official versus before 2000? I mean, all these things are obviously still done.
Yeah.
But now is it that you're caught, is it the state that sort of takes over, or is it still like common law where your two companies are going against each other, you know, or
Yeah, no, it's definitely going to be.
private parties versus, you know,
Yeah.
the state versus, so, you know.
Right.
versus a-
IDFPR would step in as a regulatory agency then and very clearly have jurisdiction. So one party doesn't have to sue the other, they can file a complaint with the state.
Okay.
Filing a complaint with a regulatory agency is generally faster, and that's less money than a lawsuit. So it's faster and cheaper, but you know, if you're looking for, you know, a big legal victory, that would have to
So,
come
I mean,
through court.
so why is it that the act itself came into place? Is it because of matters like that where people are arguing, bickering about stuff?
Yeah,
Or it
somewhat.
came to the point where it's like, let's make things official.
Or
that we
clearer,
sort of-
really, yeah, right.
Clearer, that you
Mhm.
sort of regulate it from that standpoint versus letting.
And that's the norm. Governments are doing that all over the place. When you go back to 1980, and I think it was probably Reagan who was the first one to really sort of complain in large popular voice about the bureaucrats in Washington and Springfield and places like that, it's because we're regulating more and more and more things.
So, I mean, that's essentially what it is, is sort of form of creating new bureaucracy.
It is. It's exactly what it is. In growing it, and of course, the funding of that agency then comes from where?
Yeah, that's
It
what I
comes
was
from our,
wondering.
it comes from our license fees.
But who backed the initial act itself?
The licensing
state of
authority
Illinois.
and, the licensing authority and IAR, the Illinois Association of Realtors, and most of the realtor associations are pretty proactive in helping state agencies, if we want to call it helping,
So, I
to
mean,
write their
those
license
people
laws.
with like good intentions versus some other sort of lobbyists that try to push acts through with sort of.
Yeah, in fact,
Conveyed intentions.
in fact, you'll find, if you were to look at it, and we won't really cover it in this class, the Realtor Code of Ethics, which sometimes really arises out of realtor-to-realtor disputes, you know, where two different agents, both members of the same organization, have seen things differently and have got some dispute that you wouldn't have expected to arise. That once that kind of thing happens frequently, they will suggest that resolution will get incorporated into the license law. So it tends to be a relatively friendly kind of thing, but I would also say it's not a case, the law doesn't sort of wantonly let, you know, agents sort of rob the cookie jar, if that makes sense, right? So, at least not at the state level. I'm not sure that that's true at the national level. NAR is a little bit of a different animal, but when you're talking about license laws, they seem to be pretty even-handed.
And what are the consequences? I mean, jail time, is it?
More likely, and we'll talk about this more in chapter 14, but more likely fines and sanctions. And the sanction could potentially be a temporary or permanent loss of license. And these are where, if the consumer files a complaint, that's where it'll get brought to their attention. Or it's possible that another agent would file a complaint, but it's more likely it's the other party or maybe even your own client in that case. All right, so staying with this idea of disclosure, in whatever material facts that the Seller knows those have to be disclosed. We'll talk very briefly here just about this Illinois Residential Real Property Disclosure Act. Again, it's for residential properties. It's in a copy of it's in your text. We will look at this in greater detail in Real Estate 105. We'll actually go through a case study that looks at this statute and a real case of how it was and maybe should be applied. But again, 1, 2, 3, 4 unit properties where you're not just selling to a co-owner, or it wasn't an estate or a foreclosure or new construction, almost all sellers are going to have to fill that out. And so there's a case where that's not really in the act, but that was also totally common law before that statute. And so what's a material relevant fact? This law is a way, Illinois attempt to say, well, here's 23 items that we absolutely guarantee you are going to be material relevant facts, and we're going to have a problem with if they're not disclosed. But that kind of thing also varies from state to state. You'll see different disclosure acts or requirements in different states. Anything else about that aspect of disclosure before we move on to accounting?
So would that be the person who's selling the house itself?
The seller, yeah, typically, right. Because as a buyer, you don't have anything that you know that's relevant to the transaction unless it relates to your own inability to finance. So when we're talking about disclosure here on this level, we're now, and going forward, we're going to be talking about the obligation of the seller to disclose what they know about the property. And these, the Residential Real Property Disclosure Act is obviously residential, but disclosing relevant material facts applies also in the commercial and industrial world. Accounting, there are two aspects to this. One is the earnest money or escrow deposits that get made on a transaction, assuming there are any. That's covered. And then there's also paperwork. So there's these two different aspects. So in regards to accounting, you have obligations to report to whoever it is whose money you're holding, or both parties in the transaction, that earnest money was deposited properly in the right account, and you only disperse it or change it or send it off to somebody with proper written direction. Now, as sponsored licensees, you will not have an escrow account. That's something for the sponsoring broker or the managing broker to decide. And brokerage firms have no obligation to have escrow accounts. So, for example, I don't have an escrow account. I'm not, it's too much consumer complaint, and I can either get the other broker to handle it, or if there's not another broker, I'll get one of the attorneys involved. If they don't want to do it, I'll get the title insurance company. There's always somebody else to handle escrow money. Too much consumer complaint, too much work, so I haven't had an escrow account for more than 10 years. It's never caused me a problem. Go ahead.
What if a buyer can't afford, or he doesn't want to spend the money to put an earnest money deposit in? What would it take for him to write a promissory note? Would they have to be in the contract, or is that not allowed at all?
I think there's an option in the current contract to have a note, and when, if at all, it would be converted to an actual payment is actually an option in the contract.
Okay.
Yeah, so that is a possibility. I haven't actually seen that done, but it's been in the contract for all the years I've been practicing as an option, so it must
Okay.
happen at some point. And sometimes it's even, they have the money, but they don't have it now. People who are buying, like for example, retirees, maybe they're going to take money out of a retirement account and they don't want to pay the penalty or do whatever until
Right.
they know the deal's actually going to close. Once all the contingencies are done, for example, that will put up our $5 grand or whatever.
Okay.
So sometimes it makes sense for other reasons too.
Right.
So whatever's happening, if you're going to handle that money, if it's going to pass through you, you owe duty of accounting. And there are times when we're working with documents that are partially signed and we're delivering them to the other party to sign them. By within 24 hours, we owe true copies. At least we need to have them put in the mail or sent via email or whatever to the people or to the other broker who's going to get them to their people. So forgetting we're even involved in a transaction, just going through the listing process, the listing, the sellers sign the paperwork, use the listing agent, you sign the listing, but now maybe it's got to get countersigned by your broker, which is a common thing, the sponsor or managing broker in the office. So you've got to take that back to the office, get it countersigned, get that back to these people. You got 24 hours. And people deserve, or by law, by the act, they have the right to have a copy of that. So You might even want to be able to leave them with an unsigned copy so that they've got something to refer to. Used to be some people would carry a scanner, you can probably just photograph it today on a phone or whatever if they want to have a copy of it and send that to them, or again, scan it in right away. But again, it's important to know these deadlines. This is test fodder, this accounting idea that by the end of the next business day, escrow deposits are due to be into the proper account, and paperwork plus you needs to be back in their hands, or at least on its way within 24 hours. It's not a lot of time here. So this is where, this is one of those kind of loyalty things also, that you have to make this happen. You're busy, I know, but you're in this business, you've got to make these things happen because accounting demands it, and in those cases, you probably really can't fault it. You don't necessarily have to do it physically. Maybe there's a secretary, administrative aide, you get an unlicensed assistant, which we'll talk about in the next chapter. There are other ways to get it done, but just really important to understand that has to happen. Now, with earnest money deposits, a couple things to understand is that, again, they're not required by law. They exist most of the time, and it makes some sense. The terms earnest money and escrow deposits are kind of interchangeable. Escrow simply is when you hold something on somebody else's behalf. So, if Crystal gives me her hairbrush and says, can you hold this, so I don't forget to give it to Belinda, I'm acting as an escrow agent for that. That's what escrow means. So an earnest money deposit is sometimes referred to as an escrow deposit because it's handed off to a third party, not the buyer, not the seller, but a real estate broker or somebody's attorney or the title insurance company, who then hold that on behalf of one or the other two parties. That's why the term escrow. Earnest money is just a show of good faith by a buyer that they have something to bring to the table. Well, again, we'll talk about this a little bit more later on in the course, but you should expect earnest money question on your final or at the state exam. Between dual agency, which we're talking about tonight, and escrow deposits, those are the number 1 and 2 areas of consumer complaint against licensees. So pretty much after tonight, we will have jumped the shark. The whole class is downhill after this, and that's it. Not really, but. All right, and then confidentiality. Anything given to you in confidence by your principal, by your client, must remain in confidence unless they give you permission to disclose it. And I wouldn't do it unless I had permission in writing. So a common area of this is you're representing a seller and the buyer's agent asks a question like, so why are they selling? They're fishing. They want to know, are your sellers getting divorced? Are they dying of cancer? Can we come prey on their frailty and get this house cheaper? Are they in financial distress, even if it's not a short sale? That's really irrelevant to the transaction in terms of it doesn't have anything to do whether the house is collapsing or not. Right? So that's not a material relevant fact. So it's not something you're going to disclose. So this is an important area to really understand. When we come to dual agency, this very much comes into play, this idea of confidentiality. Whatever's given to you in confidence stays there. And it may seem a little bit odd, but I've been in situations where the first thing out of the seller's mouths at the listing appointment is, we hate each other, we just want to get the hell out of here as fast as we can. I had that happen between siblings. It wasn't a divorce situation, it was 2 sisters who realized after a year they should never have bought a place together. So, that's kind of irrelevant between anybody outside that room.
Do you tell the people that it's irrelevant, or do you just say, I can't disclose that? How do you respond to
You
that?
just ignore the question. But buyer's agent says, why are you selling? Why are they selling? You can just say, it doesn't matter, that's irrelevant, or, what else you got for me that's important?
Okay.
I don't think you have to answer the truth. Every agent who asks that question
I just want to know
knows that you shouldn't give them an answer.
The proper way to be polite about it.
Well, yeah, so if a buyer's agent asks you, says, my client's not quite sure about the value, if your seller's willing to take a lot less money, how do you answer that without violating your duties to your seller? And what's your main responsibility to your seller? Get them the highest price that you can, right? So, in that case, you might want to just respond by saying something like, if your clients are interested, make us an offer, we'll take a look at it.
What if both the agents are represented by the same broker?
we'll get to that in dual agency, because what you've hit on is the whole crux of why that's so challenging. Because how do you keep something confidential from yourself? You effectively, no, right, you
For
can't.
the same company anyway.
Well, and we'll talk about that and how the difference, because, and how dual agency is defined.
What if the client tells the agent that they will take a lot less money on their place? Then can they disclose it to the other party?
I would only do that if I had that in writing. The best answer is always just encourage the other party to make an offer. Never low offer, never aggressive offer, never, whatever. But if you're just encouraging somebody to make an offer, that's understood that, they might offer less, but you're not telling them to do that. So, yeah, it would always just be, make us an offer. We'll entertain it. If your client will entertain a lot less money, property should probably be listed for a lot less money. That's my sense of that. And your question is another good one. One last thing about confidentiality. Confidentiality never dies. One of my favorite phrases that I've ever come up with. Confidentiality never dies. So something said to you in confidence remains in confidence forever, even long after the agency relationship is over. So for whatever reason, somebody gave you some confidential information of why they were selling, what their circumstances were, or whatever. Now the deal is over, long since gone, that confidentiality remains in place. Okay. This happens every once in a while, maybe 5-6 years ago. There was a law firm that came out and disclosed that their former client, that they knew that somebody in prison, who'd been in prison for 20-some years, and they'd known all this time that he was innocent, because they knew their client had told them that he killed this person, not the person who'd been incarcerated. But they never disclosed it. Why? Because their client was still alive, and when their client, supposed true killer, died, confidentiality was finally lifted, and they came out and said, hey, this guy John Doe in the prison system is innocent. We know it because our client confessed to us that he was the murderer. But they couldn't say anything for all those years. That's how confidentiality works on this kind of level. That's an extreme example, and outside of real estate agency, we're not going to go around and murder people and cover it up. The idea here, though, is the same. If it's given to you in confidence, it stays in confidence forever unless, say, ordered by a court or something like that. Questions about that at all? So there's our basic duties. Right? Care, obedience, accounting, loyalty, disclosure, confidentiality, which is, I don't know if that's really a duty or part of loyalty, but that's how they laid it out. It is possible to get a test question that lays out a scenario and you know it's wrong, and they ask you which duty is being violated. I'm not sure that's nearly as important as understanding the range of what you can and cannot do. Yet, test questions are oftentimes a little more nuanced because you need to be assessed on some basis to see if you're worthy of being, having the mantle of a real estate license. So just be aware of that it may be necessary to know it right down to, wait, which is that? Is that a care violation, or is that some other issue? All right, let's talk briefly about this, then we'll take a break. So opinion versus fact. This goes back now, to me, we're back to the idea of disclosure. This idea that the seller owes disclosure of certain things to the other party. And you, as an agent, or any real estate agent, might also disclose or say certain things that may or may not matter. So we're trying to better define what does it mean if we're revealing or saying certain things. So under this idea of opinion versus fact, you are free as a salesman or saleswoman to encourage somebody to buy something. That's acceptable. There's a little bit of buyer beware here in that it's understood that this is what salespeople do. So, puffing or puffery, this idea that you're going to kind of build up the property a little bit to sell it, is understood and acceptable so long as it's opinion and not fact. So let's say that you get this listing, and this listing is on a house that's maybe 15 feet wide by 20 feet deep. You walk into the front door. There's no basement, by the way. You walk into the front door, and it's a kind of a combination living room, dining room, entryway, closet, all sort of together. Off to the side is the tiniest bathroom you've ever seen, and in the back is this combination kitchen, you know, and dining area, and then what you think is a closet is really the bedroom. Now, you take the listing on this house, what are you gonna do? Put in the MLS and in the advertisements, something that says, come see the smallest house known to man? I don't think so. You're gonna use words like what? Cozy and cute, 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 right? Because this is what we do. You're trying to puff that up a little bit. That's what puffing and puffery are, and that's perfectly acceptable. But if you put in an advertisement that it's on a 1/4 acre lot and it's on an 1/8 of an acre lot, or something half the size or significantly smaller, that's not puffing. That's fraud or negligent misrepresentation. You have misstated a fact. You say it has a new roof and the roof is 20 years old, you have a problem because you're an expert and you've now misled somebody. So that's an important concept to understand this, you know, when can I say things like, hey, look at this, we're on a high hill, you know, and it's got the best view in the city. Perfectly acceptable because that's a matter of opinion. Look at this subdivision, it's all, you know, it's awesome ingress and egress, easy to get to the tollway. That's a matter of opinion. Yes?
I have a question. So the townhomes where I live, they have a swimming pool and a little, a clubhouse.
Yeah.
So the swimming pool hasn't been open for like 5 years, and we had a meeting where they're gonna just close it down because it needs a lot of fixture and stuff like that. But we have other townhomes that are for sale, and they're listing that, oh, we have a swimming pool and it's all this. So they're still listing the swimming pool as this working. Is that considered fraud?
No. Well, let me back up. So let's talk now about the difference between fraud and negligence, and we'll use this at least as one example. So you know, you live there, you know the pool's going to be shut down, it's never going to be used again. You say to somebody, you really ought to buy this townhouse, look at the clubhouse with a pool. That's fraud. You've lied. You know better. I come along and I'm just kind of dopey and I don't bother to ask and I'm lazy and I say, oh look, a pool. That's either going to be let slide because I didn't know, or it's going to be negligent misrepresentation because I've misled them, but I did it accidentally. So there's the difference between fraud and misrepresentation. Now, even with that, it's important to understand that the penalty to me as a licensee might turn out to be the same. Reason being, the poor buyer of the townhouse, whether you lied to them or I was just a bad agent, got the same result. They've now invested their life savings and oh, no pool.
But if they're listed it on the paper saying that,
Same way, if it's listed on the paper, it depends upon whether they know it's not true or whether they wouldn't have any way to know. So again, she's at a disadvantage because she's living in the subdivision. She's going to know before everybody else. So if it's a case where you knew or should have known, the law is going to hold you liable, particularly as a professional. But if you never work that area, it's a place where and a meeting was just held, you may not know yet, you might be able to get out from underneath that.
Just the word should just throws total chaos.
You're exactly correct. And you don't want to hang your career, right, on whether it's, am I going to be guilty or not. So if you get a test question where, you know, fraud is a possible answer and negligence or negligent misrepresentation is a possible answer, the difference there is fraud is intentional and negligent maybe was accidental. But neither one of them is a good result for you as a professional, probably. And again, in Real Estate 105, we'll look at a case, maybe a couple of cases, one where it's clear what happens to the agent and one where not so much, to get an example of the kinds of things you can run into where you could cause your own problems or things can just happen that nobody would have expected. It's a good scenario. It's a good question. Really, you'd want it all to be accurate, right? There'll be a disclosure in the MLS, a disclaimer, excuse me, on the bottom of anything you print out of the MLS that things are estimates, that there's no guarantees. Part of that is because room sizes or lot sizes aren't always exactly accurate. But in general, to keep yourself out of trouble, you want to be as good at this business as you can be. You want to verify that information as best you can.
so basically always has like, is the pool working, is everything working?
Yeah, that's a good question to ask. If you're representing a buyer, It doesn't hurt to just ask the listing agent, you know, or check at the clubhouse, is this all available? Subdivision I live in, there's a pool, there's a clubhouse, and I live in the 160 houses there, and we don't have access to it. That's there for the condo residents. And for some years, we've been able to get access to the pool by paying additional money, and in some years not. I wouldn't even know what to tell somebody if I sold my house next week, because some years we can get access to the pool and some years we can't. Depends upon how they're thinking about liability, what they're advised by their insurance agent. It varies. So in that case, I don't think I'd get into trouble if I was careful and said, in the past, we've been able to buy, you know, our own membership. If you want to look into that yourself, look into it yourself. Be careful what you represent as an expert. Right? I like to tell people, by taking this class, you're becoming a superior being. The law holds people to a reasonableness standard. That's kind of a general thing. If you get involved in some legal entanglement, even if it's a car accident, maybe you swerved to avoid some, you know, a pedestrian, but now you hit a car head on. The law is going to look at that and go, okay, is what you did reasonable? That may have an impact on how you're looked at in that situation. The reasonableness standard, once you're a professional, is much higher because you're just expected to know more. So for example, you file a bad tax return with the IRS because you really don't understand the forms and TurboTax is confusing. You're a consumer, they'd probably work something out with you. But if your job is at H&R Block filing tax returns for people and you do the same thing, that looks like a much bigger problem for the IRS because now they think you're just playing games to commit fraud or trying to avoid paying your taxes. Different standards. You're going from being a consumer to being an expert from the time you start the class to the time you get licensed. So remember that changes. All right, let's take a break. We'll come back at, let's just make it 8 o'clock, and that'll give us about 12 minutes, and then we'll finish up with this and move on to the next area.